Please be seated. We'll hear argument in 22-662, City of Austin against Powell.
May it please the court, Ms. Powell will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. Emergency responders must make split-second decisions in the field under highly pressured conditions. In recognition of that fact, only if they are reckless does liability result under the Texas Transportation Code. And similarly, while the Texas Tort Claims Act generally waives immunity if a government employee negligently causes a car collision, it contains an emergency exception. And under that exception, the Tort Claims Act does not apply to a claim that arises from the action of an employee who was responding to an emergency call or reacting to an emergency situation if that action is taken in compliance with laws and ordinances applicable to emergency action, or in the absence of such law or ordinance, if that action is not reckless. In other words, under both the Texas Tort Claims Act and the Transportation Code, the standard of care is recklessness and not negligence. And that's in recognition of the difficulty of making time-pressured decisions in emergency conditions to minimize emergency response delays, and because civilian drivers are generally in a position where they can see and hear emergency responders come and move out of the way. So recklessness and not negligence is the appropriate standard, yet the Court of Appeals, while paying lip service to this standard, nonetheless held that the record in this case showed a fact question on recklessness, precluding dismissal under the emergency exception to the Texas Tort Claims Act. And so the issues presented in this appeal first is whether the record in fact amounts to a fact question on recklessness, which I submit it does not. And there's also a statutory interpretation argument that respondent makes that the Court of Appeals rejected and this court should reject as well. And I'd like to start with the statutory interpretation issue and then turn to the recklessness issue. So the statutory construction or interpretation issue is as follows, or the point. So the argument is that the only rules of the road that an emergency operator can disregard are those enumerated in Texas Transportation Code 546.001. And because there is evidence in the record that Officer Bullock violated a rule of the road not enumerated in 546.001, namely the duty to maintain an assured clear distance, that therefore the emergency exception does not apply regardless of whether he is reckless, because his actions were not in compliance with the laws and ordinances governing emergency action. This court seems to have never squarely addressed this issue, although it came very close in the City of Amarillo versus Martin case. And in that case, the court was construing Texas Transportation Code Chapter 546 and holding that recklessness is the appropriate standard of care for emergency vehicle operators. And so the facts of the case were that a fire truck was operating lights and sirens, slowed before entering proceeding through a red light, but nevertheless proceeded through the red light as he was privileged to do under 546.001 or its predecessor. And then a collision ensued. And the dissent in this case said, okay, recklessness is maybe the general standard of care. If you are complying with these privileges or exercising one of these privileges enumerated in 546.001, but this driver failed to keep a proper lookout. And that is not an enumerated privilege under 546.001. Therefore, he should be held to a negligence standard rather than a recklessness standard. And the majority rejected that approach and said the failure to keep a proper lookout is simply a recharacterization of a privilege, which is the privilege to proceed through a red light. So it can't be the case that you can just kind of find a rule of the road not enumerated in 546.001 and then hold that operator to a negligence standard.
Well, the statute says the law is applicable to the emergency situation, right?
Yes.
Those are the laws that we're concerned with. And so if a sort of generic rule of the road that applies to drivers in a typical situation is not applicable in an emergency situation, then
I think that could be one way to resolve the case, is to say by laws applicable to emergency action, the legislature meant only those laws specifically described in 546 and not any general run-of-the-mill rule of the road. And so, and so the emergency exception still applies. I think another way to resolve it is to say 546.005 makes an operator liable for reckless conduct. So there always has to be showing that the operator is reckless in breaking a rule of the road or even a privilege, because that standard of care that he or she is liable for the consequences of reckless disregard is engrafted on all the other requirements applicable to an emergency operator. And I think it's pretty obvious, but there's just a general common sense problem with what respondent is suggesting, and that problem was present in Martin. And you can think of kind of hypotheticals where this also seems to not make sense, this theory that respondent is advancing. So, for example, if an operator is chasing a fleeing suspect, the suspect weaves in and out of traffic, and then the operator maybe tries to follow that suspect and changes lanes. Maybe that's an unsafe lane change. That would be a violation of the rule of the road. And yet it doesn't make sense that the operator cannot make an unsafe lane change without and not be protected by the emergency exception, yet can proceed through a red light, exceed a maximum speed limit, because those are enumerated in 546.
If recklessness is the standard, there's a suggestion that cumulative acts of negligence, multiple violations of the rules of the road, might be enough for a jury to determine that there was conscious indifference to the rights or safety of the others on the road. How do you respond to, I think in this case, driving quickly, driving too fast, taking the corner too fast, following too close, multiple alleged acts of negligence? Can the logical force of that many acts of negligence rise to recklessness? And if not, why not?
I don't think that they can, Justice Bland, and I think viewing each alleged act in isolation gets you to, at best, negligence and not recklessness. But I think the argument is, yes, each in isolation would not be enough. It would not be recklessness. But is there some point where there are so many rules of the road that are violated that it at least creates a fact issue as to whether the driver was consciously indifferent? I don't think so, Justice Bland. I think negligence plus negligence plus negligence plus negligence does not equal recklessness.
Okay, so what kind of situation would equal recklessness?
So I think if there were a fact question on something that really did meet the standard of recklessness, which is knowledge of an extreme risk and showing that you didn't care what happened to other motorists. So if an officer were texting while engaged in a pursuit, or if we know the speed at which the officer was traveling and the road, and there's such an extreme difference. The officer was traveling 120 miles down a 25-mile lane, or speeding, going an incredibly fast speed through a construction zone where workers were present. Those types of facts would, I think, show a fact question on recklessness.
That's not a momentary lapse of judgment?
Correct. And
How do we know that? I mean, it seems like momentary lapse of judgment could be applied to say, well, one problem is never enough, no matter how bad, and you've just said that a series of them is never enough. So I'm left wondering why we even conduct this inquiry if nothing is ever enough.
It's not that nothing is never enough, Justice Busby. The situations I was describing, I think, would show a fact dispute on recklessness, precluding application of the emergency exception, and we get to a trial. And I guess we're left with maybe I know it when I see it, unfortunately, but I don't think that any of the acts that are alleged that Officer Bullock was alleged to have engaged in, either taken alone or taken all together, get to that conscious disregard of and show that he didn't care what happened to other motorists. And that's particularly true when thinking about all the things that he did right and that showed that he was thinking about other motorists. We have the fact that his pursuit was authorized. He requested and obtained permission to engage in the pursuit. He was operating his lights and sirens, showing that he cared what happened to other motorists because he was alerting them to his presence. And we have the fact that as soon as he saw Officer Bender in front of him slowing down, he attempted to brake but was unable to do so in time to avoid
Is there any
collision.
evidence on the speed or the speed delta between his vehicle and Bender's?
There is not, and that's one of the kind of holes and problems in the case of, and the reason why on this record, we don't get to a fact
I
question.
mean, we know Bender had slowed down enough to make a right turn. If there were evidence that the delta was 100 miles an hour, that this officer was going 120 and Bender had slowed down to 20, and then you might have to, you're saying you at that point you concede there might be a fact issue on recklessness. But here it's their burden to put on the evidence of speed and they didn't do it, is that what you're saying?
That's exactly right, Justice Boyd.
How would you get such evidence?
Conduct discovery, take depositions.
Well, a reconstructionist could figure out the delta, yeah.
That's right, Justice Boyd, and that's another kind of problem in the record. So the court Court of Appeals tried to kind of infer something based on the positioning of the vehicles, the amount of damage. Maybe with an accident reconstructionist or some kind of expert testimony, we could get from the damage to the vehicles, the position of the vehicles, to the relative speeds, so both how fast Officer Bullock was traveling and how close he was to Officer Bender, and thereby get to some fact question.
Yeah, one of my struggles with this case and your opening argument about the legal rules of the road and all of that kind of feeds into this struggle for me is that if we just talk in general terms like driver inattention or failure to control speed or following too close, I mean, it seems to me if all we have is that label, it doesn't sound like you're willing to concede this, but it seems to me that driver inattention could be recklessness under some circumstances. If you're inattentive because, as you said, you're texting your girlfriend while you're in the middle of a high-speed chase, that could be recklessness. If you just merely qualify this as failure to control speed or following too close or driver inattention, that doesn't tell us anything. You have to have the underlying facts to know, is this reckless inattention or recklessly following too close? Is that, I mean, do you agree with that at least, that following too close could be recklessness?
Yes, Justice Boyd, I agree that if there is a fact such as texting while engaged in a pursuit, I think that could show a fact question on recklessness.
Failure to control speed could be recklessness.
Potentially, depending on how fast.
Okay,
And
you got to get to the underlying facts here.
exactly so.
So that's a place where it seems to me your proof feels somewhat vague. The Bullock affidavit feels a little spare. One of the things you just said was that he hit his brakes. And what I noted in the affidavit is that it says, I was unable to slow in time, which could mean that he hit his brakes or maybe that he just didn't have time to. And so it's unclear. And so I think I agree with Justice Boyd's point that the clarity and sort of facts in the affidavit are better than sort of more general descriptions, which seems to be a lot of what you have here.
I agree, Justice Huddle, that it's perhaps equivocal. The statement in the affidavit could be read to mean he braked but was unable to avoid the collision, or that he didn't have time to brake.
So who bore the burden on these underlying facts here?
The respondent.
Because typically, the plaintiff would bear the burden of proving recklessness, but if you're coming in seeking a jurisdictional dismissal, summary judgment style, don't you bear the burden of disproving recklessness?
No, Justice Boyd. The plaintiff bears the burden of showing a waiver of immunity. And that includes not only the kind of general waiver of immunity, but also the burden to show that none of the exceptions apply, which I think the court recently.
Even if you're the movant for dismissal, they still bear the burden?
Yes, Justice Boyd.
I thought you filed a traditional motion for summary judgment.
I believe it was a plea to the jurisdiction, Justice Busby, but I could be mistaken about that. Or I believe it was a combined plea and summary judgment motion, perhaps.
So are you suggesting that a plea to the jurisdiction functions sort of like a no evidence motion for summary judgment in this context that would put the burden on the other side to show recklessness rather than the burden on you to show non-recklessness?
I think that's sort of right. So my understanding is a plea to the jurisdiction is a summary judgment-like proceeding, and the inquiry is taken as true all evidence favorable to the non-movement, indulging every inference and resolving fact disputes to the non-movement's favor.
That seems bad for you. If the affidavit is very spare and there's not evidence that if you have to resolve everything in the non-movement's favor, which is the other side, then we could send it back and you could try again to offer some more evidence that non-recklessness. But you seem to be suggesting that even if it is the traditional summary judgment standard for the plea to the jurisdiction, that somehow doesn't apply?
What I'm suggesting, Justice Busby, is that respondent bore the burden of showing that the emergency exception did not apply. So the respondent bore the burden of creating a fact dispute on whether this was an emergency or laws and ordinances applicable to action were not complied with, or recklessness, and here those two prongs collapse. And so the respondent bore the burden of showing a fact question on whether Officer Bullock was reckless.
So do we have a case that says that?
I think Ms. Sparrow stands for that proposition.
I'll look at it, and that's not the way a summary judgment usually works, but because there's no burden shifting on a traditional summary judgment, even if there would be a trial.
Yes, it's a little strange because it's the plaintiff's burden to show a waiver of immunity. I think that's why the burdens are a little bit bizarre in this. I don't know if bizarre is the right word, but a little bit confusing.
Any other questions? Thank you, Ms. Ball. We'll hear from the respondent.
May it please the court, Mr. Courtney will present argument for the respondent.
May it please the court. Last year, the National Highway Transportation Administration and the United States Department of Justice issued a report detailing their investigation of police chases in the United States. In that investigation, they determined that in 38% of police chases result in an accident. Those police chases account for between 1% and 2% of all deaths to police officers in the United States. Moreover, 40% of the time, the individuals that are injured in a police chase are innocent bystanders, which is exactly what we have in this case. Mr. Powell was at a stop sign. He was not able to move someplace else. His only evasive course of action would have been to pull in front of the two oncoming patrol vehicles, running lights and sirens.
Did the study that you referenced have anything to say about the way that criminals would behave if they knew that the police were dissuaded from chasing them?
No, it's a factual study based upon the evidence of what NHTSA could determine from the reported police collisions. So in this, we don't have a fleeing suspect either, right? The police have no idea where the target vehicle is at the time this collision is taking place. We have 2 patrol cars that are rolling lights and sirens without any knowledge as to where the, quote, target vehicle is. Now, you and I may disagree as to whether or not, and certainly there's a fact question presented in the evidence in this case, is whether or not the FJ Cruiser that exited the subdivision after supposedly, 20 minutes after supposedly shots were fired, whether or not that was a sufficient basis to determine that that FJ Cruiser needed to be stopped.
Are you challenging whether this was an actual emergency scenario now?
No, I'll give them the fact that it's an emergency scenario. What I'm not going to give them is their interpretation of the statute. Not to preview the case that's coming after us, but the city of Houston, in their brief on page 20, their brief for the merits, they outline the statutory construction. And then the first decision is whether or not there's an emergency, right? The second decision is, was there a violation of law? Yes. If there's a violation of law, is it excused by the other statute? The other statute excuses 4 different types of conduct.
Well, it doesn't say, is it excused by the other statute? It has the affirmative examination of the law that's violated, and it not in compliance with laws and ordinances applicable to emergency action. I think their position is that the ordinary rules of the road are, unless the legislature says, and this ordinary rule also shall be followed in an emergency, without that affirmative indication, those are not made applicable, such that they provide a negligence standard as opposed to a recklessness standard. I think that's their argument.
And I would disagree wholeheartedly with the argument. The statute is very clear. 546.001 outlines 4 items which are excused: parking and standing in an unauthorized location, proceeding through an intersection in contravention of a traffic control device exceeding the maximum speed, or disregarding a regulation regarding paths or directions of travel. Those are it.
So the lane change that your friend on the other side mentioned,
It's a
too bad.
disagreement regarding lanes of travel. All of the
And in
cases.
your case, in this instance, you would say the following too close is applicable.
Correct. There's a statute right on point, requires you to keep an assured clear distance. Now, in this case, we also have jurisdictional facts sufficient to show recklessness, right? Because although we don't have, in Maspero, we had the advantage of having real-time GPS indications to how fast Officer Corey's vehicle was going. And so the decision in Maspero, this court's opinion in Maspero, is that at the time of the impact between the chase vehicle and the Maspero family, Officer Corey was pulling a U-turn. She was not exceeding the speed limit, and therefore the statute requiring her to have lights and sirens running, she wasn't speeding at the time, right? Next time I'm stopped by the DPS, I'm going to try that argument. Officer, I'm not speeding right now. But anyway, that's the argument in Maspero, right? Officer Corey's not speeding. Here, we know that this is much more than just a momentary inattention, right? I have 4 children, all of them are drivers. My insurance rate is unbelievable. It tells you a little bit about how my children drive. But if my children said, I wrecked by hitting a car that was going in front of me with sufficient force to destroy my vehicle, destroy that car that I hit, destroy another car, turn that car 180 degrees on dry pavement, and knock down a fence and a stop sign, I'm going to say that's more than just a momentary loss, right, of inattention, right? That is recklessness. Officer Bullock was following another police officer, lights and sirens. Either he is absolutely too close at the time, or I'm going to assume that he actually follows some of the general orders of the city of Austin, which require an officer to consider the spacing in regards to the other vehicles that are conducting the chase. And he is not paying attention to the road for a long period of time. We know the weight of the Dodge Caravan, 1,800 pounds. 2 individuals in it, we can take the airplane rule, 150 pounds apiece. That's probably light on my occasion, light on a lot of people's occasion, but that's what airplanes use. We know a coefficient of friction of a vehicle on dry pavement. We know we can extrapolate backwards based upon the fact that they flipped the Dodge Caravan 180 degrees. He's going fast, right? Because you have 2 cars that are crushed in between the 2. Each of those impacts absorbs the force, F equals MA, right? So we know he's moving fast. He's not paying attention to what's in front of him. Officer Bender is able to make the turn, right? He's conducting the same chase, right? He's able to make the turn perfectly fine until he is rear-ended by Officer Bullock. There are enough facts in this case to, all facts reviewed in the light most favorable to the non-movement, that there are enough facts in this case to get past a jurisdictional analysis. One of the arguments that comes up in the brief is, well, it can't just be any statute. And she brings up the example of a taillight being out. This court's addressed that before in terms of the nexus analysis that is normally present in these types of cases. Here, if I'm going to spot them the fact that this is an emergency situation, I think they've got to spot me the fact that the resulting injuries in this case, the nexus of those is the actions of the officer. The actions of the officer violating the law and the actions of the officer just being inattentive. You also have a certain factual question in this case as to whether or not prior to the collision although the chase had been authorized originally, prior to the collision, there is evidence that the chase had been discontinued. And so, again, assuming that that's at CR 118 to 120, then you might also have a question as to whether or not this was falls under the emergency exception.
So are you suggesting there's a fact issue on that?
I don't think I need it, right? I think there is. I think if you look at CR 118 to 120, it's clear that that prior to the actual FJ Cruiser eventually being stopped on I-35 and being found not to have anything to do with anything else in this case, the chase had been terminated, that the order was given to terminate the chase.
But certainly the evidence doesn't support or doesn't say whether it was terminated before Powell crashed.
It certainly indicates.
It's ambiguous about that.
It's ambiguous, but it certainly is able to read that way. If you're saying, I'm going to narrate chronologically, right? I'm going to talk about those things which happened first and then those things. CR 118 has the termination of the chase and then the Powell crash. So I think it's a fair reading of.
Yeah, my takeaway from reading that is the same idea I shared with your opponent, which is that in these cases which come up so frequently, it's really useful for the courts to have concrete facts rather than.
Sure, and that's a luxury that you're not going to have in very many of these cases, because it is going to be the very rare case that in the lawyerly written, police statements following an incident like this, you're going to have an officer say, yeah, I was reckless. I was,
Of course not.
Yeah.
But you could have tied together in discovery whether the chase was terminated before the accident happened.
Sure. Again, I don't think I need it. I'm willing to spot them. I think that only goes to whether or not it's an emergency exception. I'm willing to spot them, the emergency exception argument. But I do believe that the statute is very, very clear that it's a two-part inquiry after you determine it's an emergency exception. Was there a statute that was violated? Is there an exception to that violation of the statute that's provided in the, and the or being the operative term, was it reckless? I don't think what the city of Austin is asking you to do, is inviting this court to do, is to rewrite the Texas Tort Claims Act, right? And to eliminate that or out and just say the standard is recklessness. And that's clearly not what the legislature intended.
So my understanding is that your argument is that before you get to the or, you're looking at the statutes. You say that the ordinary statutes that generally govern all drivers apply because they are not withdrawn by 546.001, and thus what the legislature really wants is to find out whether or not they were negligent in their safe distance or the lack thereof. Am I accurate in understanding your logic?
I don't think the standard at that point in time is negligent. It's just violation of the statute, right?
Strict liability, then. That's really what the legislature wanted.
Right. I mean, all that's getting you is the opportunity to get to a trial. For purposes of the court's jurisdiction, it's not liability at that point. It's just whether or not the court's got jurisdiction, right? This isn't, we still got the whole trial yet to come, right? So all we're showing at this point in time is there's a violation of the rules of the road in this case for which there was not an exception provided by the legislature. If someone wants additional exceptions, they can go across the street and ask.
I think the legislature would be surprised if we were to write an opinion that says, by virtue of a statute that provides for express safe harbors, we have now turned all other rules that govern just ordinary drivers who are not in emergency exceptions into essentially strict liability for purposes of the Tort Claim Act's exception.
I'll disagree because I can never interpret what the legislature is going to believe at this point in time. However, I believe that the legislature has been very clear about those things which they accept and require then a showing of recklessness. And that those other statutory violations have to get through not only a demonstration, a factually sufficient demonstration that the statute was violated, but also through the nexus analysis that this court has already provided for. So, which isn't really addressed in this case, but certainly was addressed in Ms. Sparrow.
Does the bottom line mean that if it's one of the four enumerated things in 546.001, that the recklessness standard applies, but for everything else it's just a violation, whether it was not even negligent?
Correct. I mean,
that seems like a strange, given the statute works so hard and repeatedly talks about recklessness and has the idea that emergencies are so different. If that's really what it was, that would just be a very simple statute. We wouldn't need all this other stuff, would we?
It is a very simple statute. I mean,
But it's not quite what it says. We're having to extrapolate a lot to get there. And I just want to make sure I'm actually understanding your position before I attribute it to you.
I don't think it is anything but a very simple statute, right? These are the exceptions that we're providing for. The city relies upon the City of Amarillo versus Martin, City of Houston versus Green, and they talk about City of Killeen Police Department, City of Arlington in their brief. All of those cases are intersection cases, right, where you have two vehicles that are approaching an emergency vehicle and another vehicle that are approaching from adjacent corners of an intersection and colliding in the intersection, right? Those all deal with establishing the recklessness standard. And that is, again, one of the things for which there is a specific exception within the Texas Transportation Code. So, approaching the
Just
intersection.
before your time ends, if we think that is, what I've been talking with you about thus far is we don't really need evidence of recklessness because that's not one of the four things in 546.001. If we disagree with that and think that we're in the part that goes after the or, and it must be reckless, what evidence do you have that, for example, the safe distance was something other than negligence?
He hit the vehicle that he was following, right? He hit it with such force that he pushed that vehicle into another vehicle.
So these are the consequences. I think we have said before, haven't we, that the fact of an injury or a collision or an accident or harm by itself is no evidence even of negligence, much less recklessness.
We don't have any evidence that he actually applied his brakes. We don't have any evidence. He had to be inattentive for an exceedingly long period of time, that he is not watching the patrol car in front of him make a turn. Officer Bender was able to make the turn. Officer Bullock runs into the rear end, okay?
The second car usually has a harder time making a turn. I think we know that all from our daily life, but we have to keep a safe distance in ordinary life precisely because we know
Sure,
somebody makes an unexpected turn.
And again, you know, the general orders from the city of Austin, which we discuss at some length, talk about the requirement for spacing of vehicles. They talk about the requirement to always remain attentive.
But if we're in the recklessness side, even the violations of a policy, what is the evidence that is reckless as opposed to negligent?
Again, I think it is the culmination of all of those things, that you have a chase which is proceeding questionably in the first place as to whether or not the chase should have ever been authorized or was it discontinued. You have
That's not really part of it because you've acknowledged, I think, for this case that it's an emergency exception, right?
Yeah, that's right. You have the requirement to remain attentive, especially given the speeds that are involved, and
so any high-speed
and the
chase, you would
spacing.
have that obligation, but you're going to have the report that you mentioned. I think we're not probably shocked to hear that these are the situations in which you're going to have these accidents. And so I guess what I'm getting at is it not possible that this case is just an unfortunate act possibly of negligence? And then if that's the case, I completely agree with what you said, that your client was utterly not at fault, doing everything any citizen should do, the thing that could happen to any single person in this courtroom. And yet, because of the way the law is structured, unfortunately, that person has to bear the cost for the general public of police doing this. And so maybe that argument is best presented to another branch and not to us.
I think that argument has already been presented to the branch. I think they have directed as to how they're evaluating this. And they have also provided the limitations that are provided for in the Texas Tort Claims Act, right? This isn't an unlimited liability case, right? This is a case that is strictly under the limitations on the types and amounts of recovery that are provided for by the Texas Tort Claims Act. And in that situation, the legislature has determined, okay, we're going to accept these four things, or you're going to have to show that the officer was reckless. And I think for purposes of the jurisdictional argument, for purposes of getting past that initial step, all facts interpreted in the light most favorable to the non-movement, we've met that burden.
Any other questions? Thank you, Mr. Courtney.
Thank you, Your Honor.
I believe you have 5 minutes.
Chief Justice. I guess I'd like to start first with this policy argument that my friend on the other side made, and the problem is this court is not a policymaker. The policy is for the legislature to determine, and the legislature has made the policy decision that we'd rather embolden emergency responders and have them react swiftly and decisively in an emergency, and place a heavier burden on civilian drivers. And so this case is just an application of what the legislature has said through the statutes it has passed.
But that doesn't mean that the legislature decided that the officer shouldn't be aware if someone is simply sitting at the car at a stop sign, right?
Correct. And as the transportation code says, officers are under a duty to drive with, I believe, the appropriate regard for the safety of other persons. So they are under, that is, the legislature has said they should be watching out for others and proceeding with due care, or appropriate regard, rather. But nevertheless, they are only liable for the consequences of recklessness.
Why isn't the inattentiveness that your friend on the other side emphasized at the end, why isn't that something that creates a fact question about recklessness?
I think that inattentiveness is, in general, sounds in negligence and not recklessness.
Well, but you agreed with me that if all you're talking about is this broad category of driver inattentiveness, that can be either recklessness or negligence depending on the underlying facts.
Yes, that's true, Justice
So
Boyd.
I think Justice Young's question is, why aren't the facts that Mr. Courtney laid out about the length of time that he had to have been inattentive and so on, why aren't the facts in this record enough to create a fact issue on whether this quote-unquote driver inattentiveness was enough to be recklessness?
Yes, and I think the way to reconcile this is just standing alone, inattentiveness sounds in negligence. If there are additional facts such as texting while driving, maybe it gets us to recklessness. But what my friend on the other side was saying about the time that Officer Bullock had to react, I don't see where that is in the record.
Wouldn't it be a factor, though, that the car is parked and they're doing what they're supposed to be doing at the stop sign? Doesn't that bear on attentiveness in relation to recklessness?
I'm not sure it bears on attentiveness, and I think part of the problem too
Well,
is
if you were inattentive and had you been attentive and could see the Powell car, does that matter? Or is it more, you need evidence that you could see that there was other traffic and nevertheless proceeded? And in this case, could the officer, before making the turn, have seen the car? I know the drawing wasn't to scale, so I couldn't really tell what the record was about that.
yes, and I suppose if he saw Powell's vehicle in time to make a different decision about maybe not try to follow Officer Bender and also turn right, or just keep on going and try to loop around and follow up, reach Officer Bender at a later point, perhaps that could get to recklessness. We don't have evidence of any of that, but I think it's still sounds more like a momentary judgment lapse rather than a conscious indifference to the safety of other motorists.
Does the severity of the situation the police are responding to affect the analysis of whether they're reckless? Or is it just sort of an on-off switch if there's an emergency?
I think it does bear on recklessness, Justice Blacklock. So I think because it's in some ways, recklessness itself is kind of a needs-risk analysis where you're thinking about whether these risks are warranted given the circumstances. And I think here it's important to think about what this officer is responding to. It's a report of shots fired in an urban residential neighborhood. And so he's thinking that this person fled. There's an armed suspect who's been shooting in a neighborhood, armed and dangerous at large.
If you're right about that, then we do bring back in the facts that your friend on the other side was mentioning about the fact that they have no idea where this car is at the moment. And so doesn't that make it more reckless to do these things if you don't even know if you're going to catch up with this person?
And I don't think the record can be fairly read to suggest that these officers had no idea where the FJ Cruiser was, because in fact, Officer Bender made the right-hand turn because he heard on the radio another officer saw the car going west on Slaughter Lane. So I don't think it's fair that to characterize these officers just driving around looking for a vehicle that they had
In
no
your
idea was.
estimation, does the record clarify whether or not what they knew about the shots? I mean, because in today's world, gunshots can be a signal that something really bad is going on. And so what is your reading of the record in that regard?
So I think the general offense report, it has multiple supplements from different officers who were on scene, all of whom identified the sound they were hearing as gunshots. And there's also Officer Bender's supplement where he says the gunshots were so close he wasn't sure whether they were being actually fired at the officers themselves or just in the vicinity. So I think the record does support that this was a very serious incident and the pursuit was justified.
Just one more quick thing. Texting while driving, is that something that you would regard as negligent rather than reckless, or is that reckless inherently?
I think it may be not inherently reckless. I think it would, again, depend on the circumstances.
But I think you agreed a couple times with Justice Boyd that texting the girlfriend while doing these other things could raise a fat question about recklessness, but you also told us that negligence plus negligence doesn't equal recklessness, and I'm not sure I'm following where you're drawing this line, or maybe that was a concession you didn't actually mean to make.
Well, I think I suppose, I'm not sure where the line is on texting while driving. Certainly, if an officer is mid-pursuit and exceeding a speed limit and texting, I would say that.
Bad judgment, a lapse in judgment, surely, but maybe it's a really demanding girlfriend. I don't know.
Well, it might matter whether he's texting the girlfriend or texting a fellow officer about the situation.
I would hope that he would be talking on the radio to his fellow officer rather than texting and then taking his eyes off the road. But I think, to me, I think that would signify something more than a momentary judgment lapse.
It sounded like your answer was maybe two sort of spare allegations of negligence put together aren't enough, but if the facts showing the context of what was done make the lapse of judgment serious enough, then it could be recklessness whether there's one or more lapses. Is that a fair summary of your position?
I think I'm not sure that adding multiple momentary judgment lapses, maybe there could be so many judgment lapses that starts to get you to recklessness, perhaps.
But I took you to be saying that it's really the content of the facts surrounding each one of the lapses that then allows you to decide if that particular one is reckless or negligent.
I think if you look at all...
Like the texting while driving, if you're going through the intersection while you're speeding on it in a high-speed chase.
Yes, and I may have lost your...
I think that's fine. I think we have your thoughts on that and prior questions.
Okay, thank you.
Any other questions? Thank you, Ms. Vile. The case is submitted, and the court will take another brief recess.
All rise.